Call the meeting to order. This is meeting number 15 of the Standing Committee on Justice and Human Rights. Today is Wednesday, April 22nd, 2009. You have before you the agenda for today. As you know, by order of reference, we have before us Bill C-15, an act to amend the Controlled Drugs and Substances Act and make related and consequential amendments to other acts. Please note that we're going to leave half an hour or whatever time is remaining after the minister leaves to deal with some committee business, including Monsieur Menard's motion. To assist us in our Bill C-15 review, we again have with us our Minister of Justice and Attorney General for Canada, the Honourable Rob Nicholson. With him are representatives from the Department of Justice, Paul Saint-Denis, as well as Greg Yost. So, Minister Nicholson, I understand you'll be here with us up to 5 o'clock, is that correct?
If that's possible. Thank you, Mr. Chairman.
And what we might do, we may shorten the questions to 5 minutes and 3 minutes to make sure everyone gets a question.
Terrific.
And you know the routine, so you have 10 minutes to present, and then we'll open the floor.
I don't think I'll take that long, Mr. Chairman, but thank you very much. I'm pleased to be here once again before the committee for this review of the Bill C-15, the bill dealing with mandatory prison times for people who commit serious drug offences. And so I'm hoping, Mr. Chairman, that this process will go well and that you will be able to expedite passage of this important piece of legislation that I think is welcomed by Canadians. I can tell you there is support for this bill from many ordinary Canadians who are quite concerned about drug abuse. They're concerned that marijuana grow operations and methamphetamine production and trafficking have gotten out of hand, and they're concerned about the dangerous occupation of exporting and importing drugs into this country. They're concerned that these activities pose a serious threat to their own safety and to the safety of their communities, and they are right. Our challenge as legislators is to try to make sure that our criminal law stays current with the developments in our society. Over the last decade, domestic operations related to the production and distribution of marijuana and synthetic drugs have dramatically increased, resulting in serious problems in many of the regions of Canada. This has often overwhelmed the capacity of law enforcement agencies to be able to deal with this phenomenon. Now, these illegal operations pose serious health and public safety hazards to those in and around them. They produce environmental hazards, pose cleanup problems, and endanger the lives and health of communities. Moreover, Mr. Chairman, the organized crime groups and criminal gangs are resorting to increased violence to establish their dominance over the drug trade in various metropolitan regions of this country. Innocent people are being hurt, and in some parts of the country, there exists a serious degree of fear amongst citizens. This is not to say that all drug offenders are necessarily dangerous and that all forms of drug trades are violent. C-15 recognizes this, and this is why what is being proposed in this bill is a focused, targeted, and balanced approach. What this bill does is focus on the more serious drug offenses. Overall, the proposals represent a tailored approach to mandatory prison penalties for serious drug offenses, and they would operate as follows. For Schedule I drugs, that is for drugs like heroin, cocaine, or methamphetamine, the bill proposes a 1-year minimum for the majority of the serious drug offenses in the presence of certain aggravating factors. Now, those aggravating factors are the offense is committed for the benefit of and at the direction of or association with organized crime. The offense involved violence or threat of violence or weapons or the threat of use of weapons, or the offense is committed by someone who has been convicted in the previous years of a designated drug offense. If youth are present or the offense occurs in a prison, the minimum is increased to 2 years. In the case of importing, exporting, and possession for the purpose of exporting, the minimum penalty will be raised to 2 years if the offense involves more than 1 kilogram of a Schedule I drug. A minimum of 2 years is provided for a production offense involving a Schedule I drug. Now, the minimum sentence for the production of Schedule I drugs increases to 3 years where aggravating factors relating to health and safety are present. Now, these factors are the person used real property that belonged to a third party to commit the offense, the production constituted a potential security, health, or safety hazard to children who were in the location where the offense was committed or in the immediate area, the production constituted a potential public safety hazard in a residential area, or the person placed or set a trap. For Schedule II drugs, now those, it's marijuana, cannabis, resin, etc., the proposed mandatory minimum penalty for trafficking, possession for the purpose of trafficking, importing, or exporting and possession for the purpose of trafficking is 1 year if certain aggravating factors such as violence, recidivism, or organized crime are present. If factors such as trafficking to youth are present, the minimum is increased to 2 years. Now, for the offense of marijuana production, the bill proposes mandatory penalties based on the size of the operation. If the production is between 1 and 200 plants, and if the plants are cultivated for the purposes of trafficking, then the penalty begins at 6 months. For the production of plants between 201 and 500 plants, that's 1 year. Production of more than 500 plants, 2 years, and production of cannabis resin for the purposes of trafficking, 1 year. The minimum sentence for the production of Schedule II drugs increases by 50% where any of the aggravating factors relating to health and safety that I have just described are present. Now, the maximum penalty for producing marijuana would be doubled from 7 to 14 years. Amphetamines, as well as the date rape drugs GHB and Rihapinol, would be transferred from Schedule III to Schedule I, thereby allowing the courts to impose higher maximum penalties for offences involving these drugs. Lastly, Mr. Chairman, the proposed legislation will allow drug treatment courts to impose a penalty other than the mandatory minimum on an offender who has a previous conviction for a serious drug offence where the offence involves no aggravating factors and where the offender successfully completes the court program. Mr. Chairman, the members of the committee, Bill C-15, to the members of the committee, Bill C-15 seeks to protect the public by tackling the problem of serious drug crimes. It's part of our continued commitment to take steps to protect Canadians and make our streets and communities safer. Canadians want a justice system that has a clear and strong laws that denounce and deter serious crimes, including serious drug crimes. They want laws that impose penalties that adequately reflect the serious nature of these crimes, Mr. Speaker, and this bill does that. Thank you very much.
Thank you, Minister. Now we have time for questions. With your consent, members, I'd like to reduce the time for each question to 5 so we can all get questions in. Is that acceptable?
Sure.
Good. We have consensus. So we'll start with Mr. Murphy. You've got 5 minutes.
Thank you, Mr. Chair. Mr. Minister, good to see you again here. This bill, I wanted to zero in on the drug treatment court program and specifically and generally the amount of the degree to which there is inter-departmental liaisons with public safety and health. First, I mean, the mandatory minimum thing, I've been here 3 years, and we could have a debate on the efficacy of those and whether it'll work or not. That's really not something I want to discuss. I do want to applaud the part of the bill that talks or gives emphasis to the drug treatment courts as a way to prevent the imposition of the mandatory minimum. I think it's a great idea, and it leads towards treatment, of course, because it says to me that people with addictions, which is a bit of a health issue as well as a public safety issue, people with addictions will hopefully seek to, through the drug court situation, to treat those addictions rather than go to jail. The question I have, however, is that with the imposition of more mandatory minimums in the drug-related field, would it not lead to a concern that there will be more addicts, people with problems in the system? You may or may not know of unfortunate cases. Certainly we had one in northern New Brunswick where an individual overdosed with drugs that he received within the institution. It is rampant in the correction facilities of this country. And we recently had a letter from the Minister of Government Services for Ontario asking about the use of medical marijuana as it relates to the Department of Health guidelines. I guess the question, Mr. Minister, is, have you consulted with the Minister of Public Safety the Minister of Health with respect to what this bill, what effect this bill will have on the, I guess, increasing number of addicts, people with problems, who will be in the system, the corrections system, the health system, and what effect do you think this bill will have on successfully treating people with addictions?
Well, you covered quite a bit of ground there, Mr. Murphy. I can tell you both the Minister of Health and the Minister of Public Safety are in full support and completely aware of all the provisions of this bill, and just like the members of my caucus who have encouraged us to come forward with this legislation and encourage us to bring forward legislation in this area that has their complete support, so you can be assured of that. You talked a bit about the drug treatment courts. I'm very supportive of the drug treatment courts. It provides an opportunity for someone to break the cycle and get out of the business or the unfortunate situation of being caught with drugs or taking drugs or having an addiction. So I like the idea that they are given the opportunity, if they are prepared to complete a prescribed drug treatment program, that they can come back to court and have the charges withdrawn against them. It's a very serious business to have a criminal conviction against you, and so I can understand why this would be a huge incentive for some people to try and break the cycle of addiction and dependence and do something about where they are at with their lives. I mean, I'm careful when I describe them that we are not talking about the serious drug traffickers, the people who are basically out to destroy our society. This is not who we are talking about. There are a number of criteria. I think I mentioned a couple of them, where there are no other aggravating factors and where they are prepared to, of course, and it's always up to them. They're prepared to go through the treatment. I think this is a great alternative. But we have to move on this. I've had discussions with people, not just in Canada, outside of Canada. Drugs and trafficking in drugs are a scourge. And we have to do what we can. We have to send out the message. I am particularly pleased with, for instance, the importing provisions. They tell me the people who are importing drugs, these are not the persons we're talking about who get involved with the drug treatment courts. This is organized crime. These are the real gangsters that are bringing drugs into this country, and I want to send out a very clear message to them that if you get into this business, you can expect jail time under this particular bill, and I think that's exactly the message we have to send out. So on the one hand, we want to help addicts. We don't want people to get involved with drug addiction. We want to help them get out of that. But for the people who are in the business of trafficking or selling to children or using violence, bringing these things into this country or destroying neighborhoods, the message to them is very clear. You can expect serious consequences under this new bill.
Thank you. Before we go on to the next witness, I also wanted to welcome Mr. McCauley. You're visiting this time. Thank you. Yes, you will. Ms. Davies as well, and Mr. Allison. Welcome here. Next questioner will be Monsieur Menard. You've got 5 minutes.
Alors, merci, Monsieur le Président.
Thank you, Mr. Chairman. Good afternoon, Mr. Minister. This is a bill that is not without its merits, but it poses important questions. The first one, and of course I want to remind you of what we said a few years ago. We had a committee on the non-medical use of drugs, and it was Wendy White who tabled this motion in the House. But he was convinced of the arguments of decriminalizing small amounts of marijuana, but I don't imagine that that will happen to you. And I just wanted to speak about that because Mr. White had tabled this motion that was voted on by all parliamentarians. Now, I really understand the problem that you have here. We had said several times recently that organized crime exists because of the drug market, and all parliamentarians know that. What bothers me in your bill is that you didn't make a distinction between marijuana and other kinds of drugs. And I would like, first of all, for you to tell me why you didn't make that distinction. And secondly, do we not have reasons to think that small amounts of marijuana that could, in this case, be end up in the person being charged with something much, in a very heavy-handed way. And I know that it's one thing when there's aggravating circumstances, and I'd like for you to talk to me about that as well. And also, I would like for you to explain to me what the third-party residence aspect of this bill is about. Why is that there? And do you think that the sentences are close to what judges currently would impose?
Mr. Menard, and with respect to decriminalizing small amounts of marijuana, this will never happen under a Conservative administration. We have no intention to do that. And quite frankly, we think that in the last number of years prior to us taking government, the wrong message was being sent out to people, that somehow marijuana was okay and that we may be legalizing it, we may not, and we think it sent out the wrong message, quite frankly, to people. And I can tell you what people, for instance, have told me. I've been out to British Columbia about 3 times in the last 2 months. I can tell you what law enforcement agencies have told me with respect to the production of marijuana, because one of your questions was say, well, why don't you make a distinction, or why are you lumping in marijuana with some of these other drugs? They tell me, I don't have to tell anybody that in this country what a curse it is to start having grow-op operations. Now, I see my colleague Dean Ellison, and he knows what I'm talking about. In the Niagara area, when they've been uncovering these things, many times the house is destroyed. The people lose the house because of these operations. They are completely illegal. We want to send out the right message to these people that this sort of activity will not be tolerated. But here's what they were telling me, what law enforcement agencies in British Columbia were telling me. And this is no different, quite frankly, than what I get when I go right across this country. They're telling me that sometimes, in many cases, that marijuana is the currency that is being used to bring in other drugs from outside, more serious drugs, or other serious drugs from outside of the country. They're being exchanged. They're shipping out the marijuana out of the country, and they're bringing in other drugs like cocaine and heroin. So again, when I have law enforcement agents telling me, saying this is the currency, this helps get the business going. Boy, this lubricates the business. Boy, I tell you what, that makes me nervous.
But Mr. Minister, are you sitting in the same caucus as Mr. Pierre-Claude Nolin? Have you talked to him about this? Because I'm not trying to minimize the significance of drugs, but have you had a discussion with Senator Nolin? And can you tell me what the size of a marijuana plant is by showing me the size of it? Not 500, just one. And do you think that Pierre-Claude Nolin would support this bill?
Bill has the complete support of the government, and I can tell you that with respect to, if you're talking about grow-op production, you'll notice that there is a distinction, that we are not trying to get the one person who's grown one plant in their backyard, but we're into the people who are into the business of trafficking, and we've made it very, very clear that up to 200 plants, that if these people are using this for the purposes of trafficking, they fall within this law. Obviously, and I think you would agree with me, the people who are having 200 or 500 or 1,000 plants, they're in the business of trafficking, and this is who this bill is designed and directed at. And as I say, I made it very clear that what we're after the people who are into the business of trying to destroy lives in this country, the organized crime that gets involved with this, the people who are trafficking. This is why we have a whole list of aggravating factors. I think if you look at it very closely, as I'm sure you will, when you go clause by clause on this, you'll see that, yes, you've got it right. These are the kinds of things we want to take into consideration. Thank you.
Thank you. We'll move on to Ms. Davies. You've got 5 minutes.
Thank you very much. And thank you for coming today, Minister. I think that this is a very significant bill because it does show a very changed direction in terms of Canada's drug strategy. And I think that the central question before this committee in examining the bill, and I want to put to you, is the question of mandatory minimums for drug crimes. You're probably familiar with the Justice Department report from 2002 that pointed out that mandatory minimums are the least effective in relation to drug offences. And certainly in the US, where there was a huge movement to mandatory minimums, they're now moving away from that. Many states are repealing their mandatory minimums minimums. So one question I have for you is, what evidence do you have, or the department, does your government have, that mandatory minimums will work for drug crimes, and will you table that evidence? I think we need to see what studies you rely on, or is this just a continuation of a political position that the Conservative government carries? I think we also have to consider the consequences of this bill if it were approved as it is, and that is, for example, mandatory minimums that are 2 years or less than 2 years would be for sure an issue for the provincial courts and prison system. They would bear the cost of that. So I'd like to ask you directly, what estimated cost do you have to the provinces for the implementation of this bill? And secondly, what increase in the size of the prison population would result? I'm sure that you've done this research to know what the consequences of this are. And I guess to sort of point out what a blunt instrument this bill is, and how it's sort of using this hammer approach for all aspects, I'd like to raise the question with you how you believe that a mandatory minimum sentence for the possession of one plant, marijuana, for the possession of trafficking would stop organized crime or gang-related crime. And finally, if you could offer any observations, do you think the war on drugs in the U.S. has been a success?
Well, can I have half an hour on that one, Mr. Chairman? You've covered quite a bit of ground, Ms. Davies. I have to admit. Now, you started off your comments about mandatory prison terms. I agree with you. Trying for drug crimes. And so you have no trouble with mandatory penalties for gangs or anything else?
I'm talking about mandatory minimums for drug crimes and what your evidence
I have no trouble with that. I first of all believe, and the government has taken this as a comprehensive approach. Now, you'll know under the National Anti-Drug Strategy, we're getting the message out to particularly to young people that drugs are a bad idea. This is not the way to go with your life. We're doing that through education, advertising. We're working with non-governmental groups and government organizations to try and get the message out. And I approve that. I talked to the Liberal MP about drug courts. I agree with that. I think you say that we're using a club on this. I disagree. Sending somebody to jail for a year who's bringing drugs into this country for the purposes of trafficking, I don't think there's anything unreasonable about that. I think they should go to jail. People who are importing drugs for the purposes, and that's a determination of the court, for the purposes of trafficking. And I indicated to you, if you're speaking with respect to the grow-ops, it specifically identifies, you could have a grow-op of 100, and you may have just sold 95 plants here yesterday, and you've got 5 plants. Well, guess what? If you're in the business of trafficking, you're in the business of trafficking. But I did make it clear that this is not directed at the person. This is not a bill directed at possession or the person who grew a plant who's not into the trafficking business. Again,
I respect your opinion on that, but the question is, what evidence do you have that mandatory minimums for these drug crimes will actually work, that they're actually a deterrent?
It's been a long time, Ms. Davies, since we've had a number of these mandatory penalties here. We're absolutely convinced in our consultation with Canadians that this is exactly what Canadians want us to do. We want to send out the right direction. We have the evidence that the Canadians have told us that, and with respect to the resources, I can tell you this is welcomed across this country, and I think you can check with the Attorneys General of British Columbia and other jurisdictions here. They want us to take action on drugs and gangs, admittedly. They want both on there, but we have introduced both those, and we've received widespread support at the provincial level, and I can assure you that with respect to my colleague, the Minister of Public Safety, the resources are there and will be there for this and indeed all the legislation that we have introduced to Parliament. I hope you get behind this. I mean, I got to tell you something. Check with your constituents on this and the people back home, and I think they'll say, look, the Conservatives are on the right track. You've got to send out a strong message to the people who are into the business of destroying these things there. We have the mandate of the Canadian people who have told us, Ms. Davies, this is what they want to see us move on.
Time is up. We'll move on to Mr. Rathgaber. You've got 5 minutes.
Thank you, Mr. Chair, and thank you, Minister, for your attendance here today, and thank you for sponsoring Bill C-15, which I also do talk to my constituents, and I concur with the Minister that not only are they asking for this type of legislation, they're demanding it quite strongly, and by letter and by phone call and by email. But I do have one specific question with respect to a substance referred to as GHB, or colloquially referred to as a family of date rape drugs. And I understand if C-15 were to become the law, if Parliament sees fit to pass it, that this family of substances will cease to be a Schedule 1 substance, or will become a Schedule I substance and will move there from the Schedule 3 list. And I would submit to you and to the members of the committee that this change is long overdue. And in fact, as I understand this family of substances, they're not used normally by casual users who are or recreational users who are looking for some sort of substance high. But it's quite another matter. It's in terms of those who are in the business of being sexual predators, who are attempting to take advantage of another individual for their own sexual gratification. And I think this is a problem that Parliament needs to address. These substances are becoming prevalent in cities such as Edmonton, where I represent. Those involved in organized crime are distributing them, and they're quite prevalent in the nightclubs and in the bars in cities such as Edmonton. So, Minister, I was hoping you could tell me what the ramifications will be for those who traffic in date rape drugs such as GHB, should we be successful in making C-15 the law and an amendment to the Criminal Code.
Well, I think there's some quite serious consequences that are contained within the legislation. But first of all, I have to thank you for your support. You've been very supportive of our tough on crime agenda, and not just with respect to this bill. I've got to be fair, right across the board. You have been very supportive, and I know you are in touch with your constituents, and they are rightly concerned, and I appreciate the fact that you have brought those concerns to me. But you're quite right that by reclassifying some of these judges, we bring them within the ambit of what we are trying to do here. And again, so as I said to Ms. Davies, we want to send a clear message out to people who want to get involved with this, because they're in the business of destroying people's lives. That's what it's all about. People are into the importing of narcotics into this country. They're into the business of destroying people. That's what it's all about, or taking advantage of other people. And this is why I make no apologies for the fact that these people can expect to end up in jail if they want to get involved with this activity. We don't want them to get involved with that activity. I hope nobody would wish that upon anybody else, and I'm pleased that we do take a comprehensive approach, and the National Anti-Drug Strategy is a perfect example of getting the message out to particularly young people. Don't get involved with this. But we have to have a very clear message, and I don't think people got a clear message, quite frankly, over the years. In the late 90s and the early part of this century, that somehow, well, some of it's okay and you could take it and we're not going to charge you and maybe we're going to decriminalize it. No, that was the wrong message in my opinion. We will have to be consistent, and this government will be consistent, and we will bring in, as you can see, the list of penalties that I have indicated. We're after those people who are into the business of trafficking, the people who are into the business of producing these drugs, the people who are into the business of taking advantage of other people, or as they told me in British Columbia in very clear terms, the people who are the gangsters and the gangs who are making a living off of this. This is who we have to direct this legislation. And again, and you've been supportive of that, not just this legislation, but on gang legislation and other pieces of legislation. So again, thank you very much for your concern on that, and it certainly has been noted and appreciated by me and indeed all of us in the government.
Thank you, Minister.
We'll move on to Mr. McCauley. You've got 5 minutes.
Very much, Mr. Chair, and welcome, Minister. And I'm interested for sure in what you've had to say, and I've been involved in this area a number of years myself. And I don't think there's anybody sitting around these tables that would support drug pushers, but organized crime. And it's a desperate thing to be addicted to anything, any drug. And as Minister of Justice, you're of course responsible for putting the laws in place to pay for the crime, but it's also important to make sure that rehabilitation is there. I would just wonder, and you've indicated in your opening statement that you've traveled across this country and many places around the world in the prison systems. Well, I did too, a bit around the world, and I just wondered what type of programs. It's most unfortunate, as I said before, when you're addicted. And I know you care. I know you personally. I know you care. What type of programs, number one, will the numbers increase dramatically? Do you have any figures on what you expect to take place? Perhaps Mr. Yost or somebody might have that figure or an estimate on that. What's going to happen when you put more people in the prison system? And what type, or if there is any, rehabilitation programs? You have traveled, as you've indicated. Yeah. I'm sure you've been in institutions that portions of the institution or the institution was drug-free. And I do believe, like, they're all human beings, and I just wonder if there's any thought to putting that type of a system in place that, unfortunately, you're addicted. But if you make an attempt to straighten out your life, or there's some goal for these people to achieve, has there been any thought given to that in order to make to give the people, the human beings that are in the system, an opportunity to change their lives?
Well, thank you very much, Mr. McCauley, for your questions. And indeed, there's quite a bit of consideration with respect to people who are being incarcerated and getting into the federal penitentiary system. And if my colleague, the Minister of Public Safety, was here, he would reiterate what I'm going to tell you, is that, of course, we want these people, we want them to get help. We want them to break their addiction. We want them to have programs available to them, because ultimately these people are back out on the streets, and we want them to be responsible citizens contributing to Canadian society. We talked a little bit about, and questions from your colleague, about respect to the drug courts. The drug courts are an attempt to intervene with individuals to get them off of this, give them an alternative, them from going into a correctional facility, because that's what you're looking at. If you continue to abuse drugs, if you continue to get into trafficking, if you get involved with violence, I mean, these are all things that lead to a dead end. And so that's one of the reasons I, right from the start, said that 2.5 years ago when I became Justice Minister, I'm very interested in the drug courts, because I think they provide an alternative. And I can tell you as well, I was very pleased when the Prime Minister over a year ago announced the National Anti-Drug Strategy in Winnipeg. And again, the education components, working with people, working with NGOs. In fact, I was pleased to be in Prince Edward Island here, and I remember visiting a correctional institute with your Attorney General for young people, and that was one of the questions I had, like, are they getting help and that sort of thing, and he was able to assure me that they're doing everything possible to help particularly these young people, and I was quite impressed, quite frankly, by that visit. But this is what we have to do.
Well, thank you very much, but I was just wondering, and if you have is there any thought, like, I agree that there's anything that can be done in order to see or they can be get some help before they go to prison, but people, the majority or a large percentage of people in the penal institutions have a difficulty with drugs and or alcohol. Is there any thought within the justice system to start dealing with that within the institution itself after they're convicted, in order to put the program in place so they would have an opportunity to help themselves? That, I feel like I'm talking about a section or an institution that's drug-free. And people that are incarcerated are bright, too. They're able to get around all the systems you put in place in order to get the drugs within that penal institution. The only way, in my opinion, you can fight drugs is convince the human being that they shouldn't have the drug. That's what I'm asking you.
Well,
within the system, they're convicted, have a term.
Yeah.
Short answer.
Well, again, as Solicitor General and in charge of the penitentiary systems in this country, Mr. McCauley, you would know as well as I would all the different programs that are available in the federal penitentiary system. And my colleagues, both Stockwell Day and Peter Van Loan, have done nothing more except to enhance the ability of people to kind of get that assistance that we want them to get in our penitentiary system. And this is what we have to do, because I agree with you. We want these people to come out and become productive citizens of this country.
Thank you. We'll move on to Monsieur Lemay.
I have so many questions I would like to ask you that I wish you could stay an extra hour or two. But I'll try to go slowly and delicately with a question. Do you have an agreement with the provinces? Because your problem is not the people who wind up in jail. Your problem is going to be those who are sent to provincial jails for 2 years or less, and there will be many with this bill. So do you have a signed agreement so that these people will receive, pursuant to your bill, which is Section 5, if the person is prepared to undergo treatment, there's a problem. With provincial court in Quebec, for example, what do we do with that person? Are there agreements in place so that these programs can exist? And my second question is, when I look at your Section 3 in the bill, which is amending paragraph 7 of the Act, and here I'll give you some examples from my own practice. In case you don't know, Mr. Minister, there are very few plantations of 200 or less plants. There are many 10, 15, 20 plant grow-ops, maybe 50. So automatically, they are going to be liable to 6 months in jail right off the bat. So what are we going to do? What's the solution? I would say to you that I understand your position, but I have the impression that you're making a bill here for the big traffickers, the major traffickers, but they're not the ones that I'm worried about. There's already something in place for them. It's the small fry. I don't know how the small fry, indeed. I don't know how the interpreter will say that, but that's what it is, the small fry. The people who have 10, 15 plants are going to be subject to 6 months in jail. So but there's nothing today. I checked. There are no services for them in those prisons.
A bit of ground. The provinces are well aware of what we are doing right across the board on our tough on crime agenda, whether it's credit for time served, gangs, drugs. All of these are subject to discussions and consultations over certainly the last couple of years that I have been Justice Minister. So they're well aware of that, and they don't hesitate, quite frankly, to tell me how big a problem some of these things are. And guess what? Well, I get it from law enforcement agencies as well that keep asking us they support us in moving forward on doing these things. Again, the person who has, in your example, 10, 15, 50 plants, don't get into the business of trafficking, because this is what this is all about. As I pointed out to Ms. Davies or something, it's not for the individual who's planting it there for their own purposes. They shouldn't be doing that. They shouldn't get into this business. It's a bad business to get into. But the people who are trafficking in these, they are the ones who are going to be subject to this piece of legislation.
Avec respect, monsieur.
With all due respect, Mr. Minister, I think you should reread Section 7 that you wish to amend, because Section 7 talks about production. You have a consumer, and you have a producer, and you have the seller. And you are attacking the producer in Section 7. And you're talking about a 6-month minimum here.
Producing and trafficking in marijuana. That there's no question about it.
Je suis d'accord. Je suis d'accord avec.
I agree with you, but Mr. Minister, I agree. However, I'm saying that these are young people. These are all young people who only have 10 to 20 plants. I'm not talking about the big traffickers, the Hells Angels, the Bandidos. I know these people. I've acted for them. But these young people will find themselves in jail for 6 months minimum under this bill for a first offense.
The Young Offenders Act applies to people up to the age of 18. Now, if you're saying to me some 25-year-old young person who's into the business of trafficking drugs, they're going to be expected to be subject to this bill, yeah, that's right. If you're a young person, if you're 25, yeah, guess what? This bill applies to you. But again, we want to send, and I think we're on the same page. You want to send out a message to the people who are traffickers, the people who are bringing drugs into this country, that this is intolerable. I can tell you, people. One of your colleagues mentioned about people around the world. I got to tell you something. What other justice ministers, and I was at the Commonwealth meetings and other meetings, they tell me this is a curse, that it can destroy a society if drugs take a hold of this society. And so this is why we, or my colleagues, and I hope you join with us, I really do, join with us to send out a message that this kind of behavior, this kind of activity is intolerable, and it won't be tolerated.
Thank you.
By this Parliament.
Thank you. Mr. Norlock, you're next, and you have 5 minutes as well. And after that, I think we'll go to 3-minute rounds.
Well, thank you very much, Chair, and thank you, Minister, for coming here today and the officials with you. I've been listening to some of the questions here from some of the questioners, and what's the real issue here? Addicted people with problems and then on. Successfully treat people with addictions. Prescribe drug treatment plans. Young people who might be growing less than 50 plants. How about the person who's only one plant? And and then they'll make a statement, well, we agree with most of what you're doing and all this, but. And when I took secondary school education, after you say but, it basically negates everything you said before the but. Whoops, because the real issue is what you said after the but. So maybe we just need to just leave out the buts. This is about, as far as I'm concerned, about the people who come to me. And before I be accused of being, oh, you're just a cop and all you want to do is put bad people in jail, they need to know what I did when I was a police officer. I brought in programs like the DARE program. I worked with Rebound Youth Services. That's people who... So this would be a question. Just hold on to your hat there, Brian. And so this is all part of the legislation you brought in. There is the part of that legislation that deals with people who are addicted. But let me tell you what a lot of folks really think. Not the folks that are hung up here playing the political games and all those other things, of which every single person around this table, with the exception perhaps of the department people, are, and those others are with. We're all but here's the issue. We're talking, when I look at the bill, we're talking about drugs that are being sold just outside of school doors. And that could be the person that just grows one plant for the purposes of raising $30 to do something. Criminals start small. They don't all start with big grow-ops. They start with the small stuff, and if you leave them alone. Treatments in prisons, I have Canada's largest prison in my riding, Warkworth, and there's a very good drug treatment and alcohol treatment plans there. But you know something about drug and alcohol treatment? AA has it down straight. Number one, you've got to recognize you have a problem, and number two, you've got to want help. You can have all the programs in the world, and you can jam it down some drug-addicted person's face and down their throat, but it won't help them get cured because they don't want to be cured. So, Minister, my question is supposed to be dealing with mandatory minimums, and that's what this all has to do with. People are tired of reading in the newspaper where some provincial court judge or some judge somewhere gave somebody who sold drugs to, the drug sellers, and what do? Well, you spent the last 3 or 4 weeks or months in jail, and time served, boom, out the door, or you go to jail for 6 or 8 weeks or 7 weeks. That's what the mandatory minimums are about. We need to send a signal, not necessarily just to the criminals, Minister, and I'd like you to respond to this. Not just a message to the criminals that are doing these things, but to the people who want we politicians to pass laws that make sense to them, that the people who are committing the offences suffer the appropriate consequences. And so I guess my question to you, you've been asked about mandatory minimums. I'd like you to talk about mandatory minimums, not what they mean to the criminals, not what they mean to the Defence Council, what they mean to the average person on the street, the mother and the father out there.
Well, you've covered a lot of ground, Mr. Norlock. I can tell you that I think what we have here is a very balanced approach to the whole problem. We do want that individual who's an addict. We want to get them help, and as I've outlined to a number of questions that I've had today, that we do genuinely want to get help there. But we do have to send a message out to the individual who commits these crimes, and we have to send a message out to society that we're worried about them as well. I mean, one of the previous questions said the problem is the people who are getting into prisons. Yes, people who get into prisons are a problem, but guess what? It's a problem for the victims that these people leave behind. And one of the things that we have constantly emphasized since taking office in this country is we have to stand up for victims and law-abiding Canadians. Somebody has to speak for them. And I've told this committee before that we've instituted the first federal ombudsman for victims of crime. That's what that office is, and that individual has to do. But we have to send out the right message here that this kind of activity is not going to be tolerated. That you don't get off without perhaps a prison sentence if you're bringing drugs into this country. And I know, and I'm sure there are people who say this poor fellow, he's involved with organized crime. He's just bringing drugs into the country. Well, I got news for you. If you're one of the individuals trying to destroy this country, don't be bringing drugs into this country. And if you are, you can expect jail time in this country. And you can say, oh, the poor fellow, he only has 500 plants. It's he's just destroying a house in a neighborhood, and he's trafficking in this, well, that's not an excuse. That's not he shouldn't be into that business here. And again, we send out the right message. This is targeting at trafficking, and people who want to sell to children, people who want to sell around schools, people who have been into this business for a long time, people bringing it in and out of the country, people who are producing these drugs. It's very focused. It's very focused, this bill. And I mean, I'm hoping that this bill is going to get passed. Believe me, there's a lot of Canadians who are very, very supportive of what we are doing here, and they're looking to this committee and to this Parliament to do something about these problems.
Thank you. We'll move on to Mr. Murphy. You have 3 minutes.
Yes, aside from sort of the hyperbole that sort of dominates question period and how we characterize each other as parliamentarians, there's no doubt that we all want a safer community, and we all want to deal with issues regarding drug addiction. Drug addiction and the sequelae of all that, Mr. Minister, you rightly characterize as the scourge of our communities, and I think we all agree with that. And if you look at the principles of sentencing in the criminal code, deterrence or denunciation, you get an A+ in your speech and your ethos today. You're all about denunciation. That's part of it. There's no doubt about it. That's part of what we should be doing. On deterrence, I honestly believe you believe that this will have a deterrent effect. So I can't fault you on that. We may disagree on the empirical evidence, which there's really none, frankly. But really where you haven't really come through, I think, is on the issue of rehabilitation. Have you talked, it was an earlier question, have you talked to corrections officials? Have you talked to public safety officials, Minister Van Loan, anybody, about the effect this bill will have on the number of people who have drug problems and whether there will be enough resources to treat them? Because after all, it is about the victims. Because somebody sent away who's going to get out again, if we send them away and they come back a worse person with worse drug problems and worse need, it's ultimately worse for the victims. There ought to be something that can be done in the system. You alluded to some wonderful programs that my friend Mr. McCauley brought in or ministered or so on, but what's the state now? Does your bill increase the customerage in the prisons, and are there enough resources to make those people accessible, at least, to programs?
Well, you touched on a couple of things, and I was asked the question in the context of the gang bill. They said if a person under the new changes, the murder provisions, if the person spends 25 years in jail after they've murdered somebody as part of a gang-related activity, will they not do the crime because they're going to get an extra, say, 10 or 15 years? You know what I told them? I told them the truth. I said, I know for that last 10 or 15 years, there'll be fewer victims in Canada, and this will certainly help break up gang activity by having these people detained. And I think you should make a distinction as well, because I make the distinction. The people who are, for instance, trafficking in drugs, bringing them into this country, they're not necessarily addicted. many of these people are not addicted. And my limited experience with people in the grow-op business, many of these people, many times they don't even use the product themselves. They're just in the business of trafficking. And so, in answer to your question, say, are they going to get help? So, for their addictions, they're not necessarily addicted just because they're drug dealers. Some of them are. And again, I did more than allude to it. I mentioned it both in my opening remarks and in response to one of the questions that I was given, how supportive I am, for instance, of drug courts in this country to provide an alternative to the people who are addicts, and building on the programs and the federal institutions that help these individuals. And you heard Mr. Norlock was just talking about the excellent programs that exist. And so, yes, my colleague, the public safety minister, who is responsible for the federal penitentiary system, very aware, very supportive of getting people the help they need. But we can't characterize that because this bill is targeted at traffickers that these people are also addicts, because in many, many cases, according to law enforcement agencies, in fact, they're not. They're just in the business of destroying other people's lives with drugs. And so we have to be very careful. But again, as I indicated in my opening remarks, Mr. Chairman, this represents a very balanced approach. This is very reasonable, and I hope that this has the unanimous support of the members of this committee.
Thank you. We have time for one more question. Mr. Moore, you've got 3 minutes.
Okay, thank you, Minister, and for your work on this bill as well as all the others that you're sending our way as a committee. And you did touch on this on a couple of your answers, but just I do want you to speak a bit about something that certainly the police and attorneys general have made this committee aware of, and that's disrupting criminal enterprises. That's the notion that, we just passed through committee the other day, C-14, dealing with gang violence. The notion that at some point, through the good work that our police do and our prosecutors, we have to have sentences that disrupt the enterprise or the activity, whether it be gang violence or trafficking in illegal drugs that, as you rightly said, harm our community. So could you comment, I appreciate what you've said about rehabilitation and ensuring those that are in need have the resources they need to get help. And I think that is a goal that we all share. We want to see every Canadian get the help they need to be productive members of society. But when it comes to these criminal organizations and what's necessary to disrupt their activities, could you comment a bit on how this bill fits with that goal?
I've been pleased to do that, Mr. Moore, but I would be remiss if I didn't single about both you and Mr. Petit for all your work as parliamentary secretaries of the Justice Minister. I think I've indicated to you before I was very proud and pleased to be a parliamentary secretary to 3 Justice Ministers starting in the late 80s, and what a great experience that was for me, and a great training ground, quite frankly, to take on the role of Minister of Justice, though we're not contemplating any changes in the near future, just to be clear. But thank you again for you and Mr. Petit for all that you are doing, and quite frankly for your support of this. But I mean, one of the common themes that we have had throughout our legislation is exactly that. We want to disrupt the criminal activity. I indicated to you that when we made it tougher for people to get bail, we reversed the onus on people who have got a record of dealing with firearms and firearms offenses, putting the onus on them to get out on bail. I can tell you what police officers say to me. They said, this sends out the right message. If the person who took a shot at you is back out on the street in a few hours, this actually sends out the wrong message to a neighborhood. It sends out the wrong message to witnesses and to the victim. And so what we have been attempting right across the board on these things is, if you get some of these people off the street, that's what they tell me. That's what they're telling me in British Columbia. If you get some of these people off the street, it disrupts the criminal activity that that they're a part of. That's exactly what we want to do. We want to break down these gangs. We want to disrupt their activity. And this bill is a perfect part, a perfect component of what we have been trying to do, is to worry about victims and law-abiding Canadians, and at the same time disrupt criminal activity and try and send a message to these individuals that this is not the way they should be living their lives, and they should straighten themselves around. We're prepared to help them, but they've got to get that message that what they're doing is wrong and will not be tolerated.
Thank you, Minister. Before you go, I've got a short question. We've dealt with rehabilitation, we've dealt with deterrence, we've dealt with denunciation. What we haven't discussed specifically yet is protection of the public.
I know.
And I think most of us would agree that the large number of drug dealers that are arrested time and time again. They're in, they're out. They're repeat offenders, and for every crime that they're actually convicted of, many of them have 10, 30, 50, 100 or more crimes that they've committed for which they've never been caught. And it seems to me that when we are talking about mandatory minimum sentences, we're presumably talking about longer terms in prison for people who are a danger to public and are repeatedly offending. Could you comment a little bit about the protection aspect of implementing mandatory minimum sentences? Just briefly.
I don't think there's any question about it. I mean, you get an individual who is in the business of violence, in the business of destroying other people's lives. I mean, you're just doing society a favor by interrupting their criminal activity and doing something with that individual. It's like the case I said, where they said, well, is the guy going to not commit the crime? He's going to get 25 years in prison instead of 10. I said, well, I know Canadians will be a lot safer that last 15 years. For sure, we can all agree with that one. And this is ultimately what we want. So ours has always been a balanced approach, Mr. Chairman, and I thank you for your interest and support in this area. And I can tell you that we are continuing. We're continuing giving Canadians what they want, what they deserve in the criminal justice area. And again, with respect to victims, I'm always pleased, always. I wish I got more questions, quite frankly, about the victims, but you know, I don't get that many, but that's life. But that nonetheless, they are still a great concern to me, as I know they are to you and to many of our colleagues. So again, thank you very much for the opportunity.
Thank you.
And I think the departmental officials will be here for be able to stay. Are they not, or no?
No, I believe
okay,
we're not going to deal with some committee business. So thank you, all three of you, for coming.
Well, listen,
We'll suspend for 5 minutes. We'll reconvene the meeting. You've got before you the motion dated April 20th from Monsieur Menard relating to the Hells Angels and other criminal organizations. You can read the motion yourself. I'm assuming you want to bring this forward, Monsieur Menard?
Merci.
Thank you. The idea is the following. I know that we are studying organized crime, and I know that there are several bills that deal with organized crime. But I think that it is a good time to try, as legislators, to really focus on a very specific objective, and which is how can we make a certain number of criminal organizations illegal, mainly the Hells Angels. We can't wait until we've wrapped up our study on organized crime in general. I think that there are expectations so that under which we really could do a very specific study. I think this could be done in 2 or 3 meetings. So this is what I'm proposing to the meeting. 2 meetings to hear from the witnesses and 1 to draft a report. There are a lot of editorials in Quebec that are asking parliamentarians to do this. I think I have a good idea of how we can do this. We heard from Mr. Randall Richmond last week, as well as from Mr. Latulippe. Other people want us to do this too, so I understand that the government's not going to support the motion, which disappoints me somewhat. The feeling apparently is that it should be done within the context of other bills, but I think that's a mistake. I think we could do this specifically. I'm ready to receive amendments. I've limited this to Tuesdays because I don't want to delay the study of existing bills. I know that we've committed to C-15. There will be theft, identity theft rather, and car theft. There's the social condition. So I did not want us in the end to slow down any of the other work that the committee is doing. But I think we must do this, and I don't think that we can wait until we have wrapped up the organized crime study, which is going to deal with many other considerations. So I really think that we have to support this motion, and that is the reason why I tabled it.
Is that any testimony that we receive in camera or in a private meeting, we want to make sure that we don't disclose that, including the identity of those who give testimony of those. Just want to make sure that...
We're not in camera.
No, I understand that we're not in camera. I just want to make sure we don't take information that we received in camera at a previous meeting and disclose it here. Just a gentle reminder. Anyone else on this motion? Mr. Moore.
I don't want to belabor or have a big debate on this. I do want to make the point, though, that we have a very significant number of bills that we're either dealing with or coming down the pipe. We just passed through the committee the bill dealing with gang activity. We've got the one that was introduced here today on drug crime. We have one on auto theft, and there's others, credit for time served. So for us, I mean, we're all busy. We all, I assume we're all busy. I know most of us around this table are. To take 3 days to have hearings on this very specific issue, I mean, we could do that. I think it sets a precedent that anytime someone thinks we want to study some narrow issue, we take additional days. And they're days that I don't, frankly, think most of us have the time to do. So these types of questions, this can be put to experts that appear when we have committee meetings. We have regular committee meetings on all of these bills. Many of these bills touch on aspects of organized crime, including the one that we just the one that we just passed through committee. So I think it's appropriate to put these type of questions to experts that appear on our bills every week. But to take 3 days to study this, I don't support that. We have a lot of bills that we're dealing with, and we only have so much time to do it in. So that's why I'm not going to be supporting this motion.
Mr. Murphy?
What I don't hear from Mr. Moore is that he's opposed to the motion in principle. So I guess what we're caught with is a scheduling issue or a priority issue. I wonder if Mr. Menard would consider amending his motion with respect to that second line, which really talks about the when, because what I hear from Mr. Moore is that there are priorities legislation, which some of the parties are agreeing to have expedited. Perhaps we could, I'm just suggesting, perhaps we could do this over a series of weeks rather than do it in one full week to avoid the undoubtable blame that will come that we're somehow delaying or frustrating the government's program, which is not the intention. It's a motion. The member has a good motion. There ought to be a way to accommodate it without slowing the business of government legislation. But it's the ball's in Mr. Menard's court because it's his motion.
Thank you. Monsieur Menard.
Mais cette motion ne va
Yes, but this motion is not going to slow down the government's program, because if this motion is passed, we're going to sit on Tuesdays, and we don't have a regular meeting on Tuesdays. Secondly, it's not true that we can ask questions easily of each witness. What we're talking about is drafting a report here. So now maybe we can do this in 2 meetings if the government wants to amend the motion. I don't think that there is a bigger threat to us as we speak than Hells Angels and groups of that nature. So the government says that they are committed to the fight against organized crime, but they don't want to talk about the ways to make these groups specifically illegal. You heard the testimony as well as me, and we weren't in camera when we talked about C-14. You heard people say that the biggest favor you could do us would be to work on making the Hells Angels illegal, because every trial they have to start the same arguments over again. So I don't understand the parliamentary secretary saying that. We've had several editorial writers who have asked us to do that, several newspapers. Now, if Mr. Murphy wants to propose an amendment, I think it's better personally to have specific dates because it obliges us to work in a concrete fashion on this. But if Mr. Murphy feels that maybe we can hear from the witnesses in a single session or meeting and do the report in 2, that's fine. I'd be more comfortable to having specific dates, but the parliamentary secretary has to understand as well that the committee's agenda cannot only be dictated by the government bills that we've been sent. The committee has its own concerns, and I don't want to slow down the study of government bills. That's why I say we can do this on Tuesdays, so I don't understand. But if Mr. Murphy wants to move an amendment, perhaps we could just do it on the 5th and the 12th, for example, and leave aside the 26th. But we can't say that we're not going to study this and just fold it into organized crime in general. There's an emergency here. There were 156 arrests, and 111 of those concerned people from the Hells Angels. And I think we have to try and make this group illegal.
I know that we have been doing a study on organized crime, of which the Hells Angels are a major part. There's no, I don't think there's any doubt there. And I was concerned with regard to some of the things we heard, and I believe, I think it's public knowledge that in every single case, in order to prove an organization is organized crime, you have the prosecution has to prove that part of the case, and one would think we would be able to come up with a reasonable way of just saying if you belong to this organization, that or the other thing. And perhaps we need to look at that from a strictly legal point of view. Will it pass some kind of challenge by the charter that makes everything better in this country? So I think I'm disposed to want to do this, but I need, you know, every time these things come up and somebody says, well, we'll just sit a few extra days and I'll put it on a day that this committee doesn't sit, but I don't know about you guys, but I sit on public safety and it does meet on Tuesdays and it does deal with issues that are similar to this committee. So by somebody just saying, well, it won't overburden us because I'll put it on a day this committee doesn't sit, some of us sit on multiple committees, and before anybody says, well, you just get a replacement, I think the reason why we're on a particular committee and committees is so that we can follow through, and that the value of the committee work means more than if it's always a replacement or that. So I think Mr. Murphy brings up an important issue. So I think we have to get around this. I really am reticent to want to sit on extra other days because a person on the committee thinks that this is the most important thing that ever happened. Thank you.
Okay, we'll move on to Monsieur Petit.
Thank you very much. I would like to offer some clarification on this motion. I would point out to you that Mr. Réal Ménard's colleague, Mr. Serge Ménard, who's my former minister in Quebec of Justice, and who was in that position during the war against the biker gangs, says himself that this is not the right thing to do, this motion. It's my former justice minister in Quebec during the gang wars. It's Mr. Réal Ménard's colleague, Mr. Serge Ménard, and he's saying that this is not the way to do things. And he gives the following argument. He says that we will ban the name Hells Angels, and all they have to do is change their name, and they'll start over again. So we'll just be following them in that way, chasing after them while they keep changing their names. So he says that there should be a different method that should be in the criminal code, that is to make them, it's more in line with what we've done with terrorists. So I think that we should follow Mr. Serge Ménard's advice, Mr. Réal Ménard's colleague, and follow what he's doing in Quebec. I think we should vote down this motion. However, that doesn't mean that the substance of this motion brought by Mr. Ménard is bad. He himself has had a young person killed in his riding by an explosion set by the Hells Angels. So I say the substance of the motion is very good, but I think we should follow Mr. Ménard's colleague's advice, Mr. Serge Ménard's, and follow his logic.
I mean, if it's the will of the committee, then I mean, obviously it's an interesting topic, but one premise I kind of reject is that we're never interested in studying. We are in the midst of a study on organized crime. It was put forward by Mr. Menard that we study organized crime. We're going to be traveling, my understanding, unless I missed something, we're going to Vancouver next week to study organized crime. So let's not, let's not say that we're not interested in studies, but we can't have like a flavor of the week where we take time out of I mean, I'm sure we all have something scheduled for those days. I'd be very surprised if everyone around here didn't have something scheduled at the time you're talking about. So, number one, we're busy with our regular scheduled committees. We have other responsibilities. We're conducting a study right now on organized crime, of which the Hells Angels are a member. And now we want to have another study on some specific, I think it's going to be the same type of witnesses. Witnesses you could put the question to in our study on organized crime, but I do want to say that it's certainly not correct to suggest that we haven't conducted studies that have come from members of the committee, particularly Mr. Menard, who we've had several studies that you've initiated. So, I mean, if it's the will of the committee to study this on Tuesdays, then I guess we'd have to make room for it. I don't support it. I think we're dealing with government legislation. The witnesses that are going to be here are going to be here for those other sessions, and we can put those questions to them. I've never seen opposition or government members limited in our questioning by the topic at hand. We usually have pretty free-ranging discussion with witnesses.
Monsieur Menard.
Well, two things. We could very easily create a subcommittee if that doesn't cause any problem. And secondly, I repeat, the issue of organized crime is much broader than the motion I'm moving. There is a certain timing at stake here to make them illegal in the eyes of the law. We're not obliged to take 3 months to do so. And secondly, thirdly, earlier on, my Mr. Petit, my colleague, invoked my colleague Mr. Serge Ménard, and I have a great deal of respect for him, but he was proposing something else. And I am invoking the position of the Bloc Québécois, but Mr. Serge Ménard's opinion is actually not that of the Bloc Québécois. His is something else on this, and there's something that Mr. Petit did not understand. He did not wish to be inspired by the anti-terrorist legislation. There's something he didn't understand correctly there. And I don't understand why this motion would not be supported, and I think it's incredible that the government would say that they want to fight organized crime, but they don't want to confront the main threat.
We have Monsieur Lemay, Mr. Rathgaber, and Mr. Murphy. So we'll go to Mr. Lemay.
No.
No.
I agree with my colleague, the parliamentary secretary. With all due respect, Mr. Menard, and I think you encapsulated yourself in your previous comment that organized crime is much broader than the motion that you are moving. So by definition, the motion that you're moving is within the parameters of the organized crime study. I fail to see how they're different. It may very well be that after we are finished our trip to Vancouver and the rest of our organized crime study that we make specific recommendations to the government with respect to dealing with Hells Angels and other criminal organizations, and perhaps we'll develop a mechanism that the government may or may not accept in terms of making them illegal and making there less barriers for Crown prosecutors to have such organizations so deemed. But that fits perfectly within the mandate of our organized crime study, and I will be voting against your motion.
Mr. Murphy?
Well, just briefly, this is so different than our organized crime study on the one point. And it's, the motion asks us to examine the legal avenues for declaring groups illegal. And that's really got nothing to do with our crime study. I guess what I'm saying is the witnesses for these, and I'm going to propose 2 days of hearings, are going to be constitutional people. They're going to be people learned in associations law, people who are going to be cognizant of bad faith under Ron Corelli and all this stuff. It's going to be quite different than hearing from people involved in the pursuit of organized crime gangs. So for that reason, I think it's a real reasonable study to undertake on Tuesdays, which doesn't mar the government agenda and legislation. But I do think we have a lot of things to do, and our whip is telling us too that we have other people involved in other committees. But 2 days is not over strenuous to all of that. So I propose that the motion be amended just by striking out the word, the word and 26, and I suppose putting and in between 5 and 12, Madam Clerk. That's all.
Okay, friendly amendment. Well, I don't know if it's a friendly amendment because it would have to be agreed to by everyone here. But you're making it as part of your motion, Mr. Menard, is that right?
Oui, d'accord.
Right. Fine.
Should be debating the amendment. So, any further discussion on the amendment? No. Mr. Murphy, if you want to just clarify again exactly what the amendment is.
Well, the motion would read the same, except you take out 26, and the and would be between 5 and 12.
Any further discussion?
That's all.
That's fine, thank you.
Given the fact that there may be some conflicts that various members of the committee may have, it may be helpful to reword the motion to provide the clerk and myself an opportunity to check in terms of the next, say, 3 or 4 Tuesdays and Thursdays that might be available, and to also find out exactly what times are available. It may turn out that the 5th and 12th may not work for everybody, but the 5th and the, 26th may be available. If you want to leave it in our discretion, that would change the motion somewhat. Monsieur Menard.
D'accord. Moi, dans le fond,
That's all right. But the important thing to me, and I think this is Mr. Murphy's objective as well, is that the committee have 2 meetings by the end of May. And after that, it would be up to the chair to call the meetings according to what's available, as you wish. But what's important to me is that it be done by the end of May, that we have the report. And if Mr. Murphy's comfortable with that, we can just say in the wording that we will have 2 meetings on it before the end of May.
Any further debate on the amendment, which is to basically set the end of May as the time in which these 2 meetings will be held? Is that correct? Seeing none, we'll have a vote on the amendment itself. All those in favor? Opposed? Motion is carried. And we go to the main motion as amended. All those in favor? 1, 2, 3, 4, 5, 6. Opposed? 5. The motion carries. Congratulations, Monsieur Menard. And with that, we're at the end of our agenda. We'll adjourn.